All right, we'll call the next case Deutsche Bank versus LIPPI. Good morning.
Good morning, Your Honors. May it please the Court, my name is Suzanne Hill, and I represent the appellant, Deutsche Bank, as trustee for the GCAMP 2006 FM1 Trust. I would like to reserve 8 minutes for rebuttal, please. This is a case, Your Honors, where the trial court dismissed a foreclosure complaint with prejudice on two alternative grounds. The first ground being a failure to plead standing to bring the foreclosure, and the second ground being as a sanction for what the court described as the violation of numerous court orders. I submit...
Just out of curiosity, have you read the Harvey case, Harvey versus Deutsche Bank, came out a couple weeks ago?
Yes, Your Honor.
You didn't think that you should supplement?
She did.
Oh, you did supplement? I did not get that.
I did. We filed that.
You got it yesterday.
I will note that
I got it today.
it's not
I didn't get it.
final yet, however,
Right.
but we did want to supplement
Right,
the
you've seen
record
it.
with that.
Okay. All right.
And again, Harvey doesn't, in terms of dismissal and the issue of being a holder,
Well, Harvey goes to the standing issue.
correct, and it doesn't really say
Well,
anything
well,
different. I'm sorry.
Okay, we'll let the appellee address it.
Okay.
I was unaware that you had supplemented, had done a notice on that.
Yes, Your Honor. I apologize. It was yesterday, but again, it is not final, and I do admit that. But Harvey, again, reiterates what the 4th DCA already said in Riggs, which, of course, I believe recognizes the standing as being the holder of a mortgage note.
So let's talk then. Let's go to not the standing issue, but the other basis for the dismissal.
Yes, the other basis then, Your Honor, would be a dismissal under the Ham versus Dunmire or the Kozel factors as a sanction. And I submit that the record in this case certainly does not support a sanction as severe as dismissal with prejudice. The trial court's order, first of all, the trial court under Tubero was required to make findings of fact to support that the conduct in the case was willful, was contumacious, was bad faith. And there were no...
Did the trial court make any findings? It's apparent that the trial court was not happy with the conduct of Deutsche Bank, or at least its attorneys. Did the trial court ever make a determination as to what actions were taken by the attorneys and what actions were attributable to Deutsche Bank?
Well, I think that you can glean from the order that the trial court attributes this alleged failure to plead standing as being a violation of the numerous orders to file an amended complaint as conduct on behalf of the attorneys. I believe you can glean from the order that the trial court also deemed this failure to comply with the mediation order as conduct by both the attorneys and the litigant or the party, Deutsche Bank.
Was there any sort of an evidentiary here? Well, two questions. First, how was the issue of the alleged lack of authority of the representative of the lender who shows up at mediation, how was that brought to the court? And secondly, to what extent, if any, did the court have an evidentiary hearing to determine, in fact, what authority that person had?
There was no evidentiary hearing. And it was only brought to the court by the argument of counsel.
Was there any motion or other pleading that said, Judge, they violated your order, the person that showed up didn't have the authority to do anything?
I believe that the motion in which that is raised is the defendant's amended motion to dismiss, and there's an amended or an original motion to strike pleadings, which raised in part that the person who appeared at mediation was not a representative of the plaintiff. I don't believe
how did the court make the determination that the representative that showed up at the mediation did or did not have the requisite authority required under the mediation order?
I don't believe the record really reveals how that determination was made, other than the court just relied on the statements that were argued by defense counsel at the hearing.
Is it a disputed issue as to whether the person that attended mediation had authority to settle?
I don't know if it's a disputed issue of the record. There was a mediation report filed by the mediator that simply says there was an impasse. Mediation was conducted. There was no, in fact, I believe...
No, but if you don't send someone who has authority to settle the case, that's a huge problem. And particularly in the foreclosure context, when banks are notorious, and Deutsche Bank has a reputation along that line, not of record, but just has that reputation of being very difficult to get someone to talk to you about the loan.
Well, I think in this case, however, it was clear from the very outset of the filing of this complaint that this particular loan was being serviced by America's Servicing Corporation, ASC. The fair debt letter that's attached...
Who filed the foreclosure action?
Who filed it?
Right.
Deutsche Bank as trustee.
So, and so Deutsche Bank has to have somebody at that mediation with some authority.
Correct.
Did they?
Yes. And that was the servicer. And the servicer was known from the outset of the litigation. The fair debt letter specifically indicates that the servicer is America's Servicing Corporation.
But here's my question. If I understand the way this transaction is structured, Deutsche Bank alleges to be the trustee for that long list of acronyms that you gave us, who I take it...
The securitized mortgage pool.
Right. So it's a big pool of mortgages. They're the trustee, and the loan is serviced by whoever America's Service Corporation is, right?
Correct.
So it's hard to say exactly, what I keep reading in the newspapers anyway is because you've got one company that does the servicing, you've got another that's the trustee, and then you've got a bunch of mutual funds or hedge funds or little old ladies that own these pieces of these mortgages. It's hard to find anybody who has the authority to say, I'm willing to take a haircut on the deal and write the loan down to this or renegotiate. My question is simply this. What evidence in there is in the record that would indicate one way or the other that the person that came from America's
Servicing
Corporation either did or did not have the authority to say, we're going to write this loan down by 50%, or we're going to reduce your interest rate, or we're not going to do anything? I could show up and do an impasse. So the fact that there was a warm body there that impasse doesn't show me much. But what I'm trying to understand is, what record evidence is there, if any, that the person who showed up from America's Service Corporation had that authority to take a haircut or didn't? And if he or she didn't have the authority, I would agree that that would be a violation of the mediation order that says show up with somebody that's got the authority. So what was before the court that showed what authority that person had or didn't have?
Well, I would point to, Your Honor, the numerous letters that the defense attorney himself filed to say, I've been negotiating with the representatives from ACS. He was negotiating with them in 2007, even before this foreclosure was filed, in an effort to resolve this foreclosure in lieu of or before a foreclosure could be filed. So ACS has been involved in this case as a servicer, as the entity with authority with respect to this particular loan from the outset in even preceding foreclosure. So the fact that a representative from ACS appeared at mediation was no news, not even to defense counsel.
But I'm still trying to get an answer. Is there any record evidence that would indicate to us or to the trial court that the person who showed up actually had the authority without consulting mission control or anyone else to say, okay, done deal. You pay us X and we're done, or we'll take a 50% haircut, whatever. That's all I'm trying to understand.
Correct.
Is it there or is it not there?
I don't know that there is that specific piece of evidence. However,
do you agree that the typical mediation order that says show up with someone who has authority would require that the person who's sitting in the room have the ability to say, all right, here's what we're willing to do, and if you can do it right now, we got a deal?
Correct.
Did that person have that authority, or is there any evidence to suggest?
I believe...
Because every case that I read, and of course we only see at the appellate level a very small fraction, is nobody ever shows up with that authority. They got to go back and consult with 42 other people and through 15 committees, and ultimately 6 months later you get an answer of, no, we can't help you.
I believe that there is no evidence to show that she did not have any authority. At a minimum, what the trial judge had before him was defense counsel arguing, well, the person was not a representative of the GSAMP trust. But counsel for the plaintiff clearly represented to the court that Ms. Smith was a representative of the loan servicer and had authority. And in fact, they conducted mediation, according to the attorney who argued, for several hours. They reached an impasse, but that does not mean that the person there lacked authority to settle. It just means that the requirements to perhaps modify the loan were not satisfied by the financial disclosures that the defendant made.
Well, if they teed up the issue that said that your representative did not have that authority, did you need to come forward and demonstrate that they did have the authority to resolve the problem?
I don't believe they teed it up in that fashion. They teed it up because they wanted to say that the person there was not a representative of GSAMP 2008 FM1. But the person there was a representative of the servicer for the loan. And that is a fact that was established and without dispute, because even defense counsel in the letters that he attached to his motions admits that he, in fact, negotiated this particular loan with ASC, the servicer. So by all accounts, the letters that are attached, the pleadings, the fair debt letter attached to the complaint, and counsel's remarks indicate that, yes, the person there was an appropriate representative. I believe
you've got 7.5 minutes if you want to hold on to some time.
Yes,
one question before you go. Did you specifically raise the endorsement in blank? We physically hold the note, therefore we have standing. Was that argument pled and specifically raised to the trial court?
Yes, I believe it was. The original note was filed with the court.
I understand it was filed, but when the standing was contested, was the argument made, well, there's an endorsement in blank, we've got the note, we therefore have standing?
Well, yes, the note with the endorsement in blank was attached to the second amended complaint as an exhibit number 1.
I understand that, but that doesn't mean that the argument was made to the trial court judge that establishes standing.
I believe it was. The attorney arguing specifically referenced the UCC and specifically referenced 673.3011, which holds that a holder has the right, and she referenced the original note.
Okay. All right.
Thank you.
Thank you. Good morning.
May it please the Court. My name is Shannon Kane on behalf of the homeowner and appellee, Mr. Tony Lippi. With me at counsel table is Mr. Rick Rumrell, who is Mr. Lippi's trial counsel. As plaintiff's counsel indicated, the order under review did two things. It first of all dismissed the plaintiff's second amended complaint with prejudice because over a 2-year period, the plaintiff failed to allege or demonstrate that it was the proper party to bring this claim.
Okay, so that would mean that Mr. Lippi, who received money from a bank to finance a home, walks away from that debt without any responsibility, correct?
Well, I suppose so, Your Honor.
Okay.
But
right. And so that kind of puts the concept of the appropriateness of the sanction, assuming for the sake of discussion that there were violations of court orders, whether it be discovery or otherwise. What evidence was there that would justify that type of sanction?
Okay. First of all, Your Honor, the court's order that's under review demonstrates factual findings that at least 5 court orders were violated, in addition to other misconduct. Beginning with... Is
there a finding that the behavior was contumacious?
There is a finding of willfulness, Your Honor, against both the plaintiff and the attorney. Now, as I believe plaintiff's counsel acknowledged, the court specifically found that the plaintiff was complicit in violating the mediation order, which required a representative from the lawful holder of the note to appear at a mediation with full authority to settle. Now,
is that exactly what the mediation order had those words in it?
The mediation order specifically requires the lawful holder of the note to appear. Now, what we have in the record is a transcript where plaintiff's trial counsel acknowledged to the trial judge that they sent someone from ASC who is the servicer. What they indicated at that trial, at that hearing, was that the lawful holder of the note is Deutsche Bank. So they completely acknowledged that they violated that mediation order by sending someone.
Why can't Deutsche Bank, just like anyone else, have an agent? I mean, it seems to me that you can have a principal-agent relationship. I mean, if I hold a note and I want to give a power of attorney to Judge Cohen, as foolish as that might be, to act as my agent.
I'll work hard for you.
That's real. I mean, why can't I do that? So again, I mean, if in fact that Deutsche Bank is the lawful holder of the note and they want to appoint ASC or Mickey Mouse and give Mickey Mouse full authority, that I'm concerned more with the authority than who they send. But if in fact they want to appoint Mickey Mouse as their lawful agent to act for them, where's the problem? I mean, that seems like it's basic principal-agent law.
Well, first of all, Your Honor, by way of background, the trial court was having a great deal of trouble simply getting the plaintiff to tell the trial court what GSAMP is. We could not get an answer as to who the plaintiff in this case was. Deutsche Bank is a trustee for this GSAMP 2006 FM1.
What difference does it make? What difference does it make? If Deutsche Bank is a trustee for GSMP or Mickey Mouse or anybody else, what difference does it make?
Well, it makes a difference because the person who's actually bringing the claim has to be authorized. They have to be able to bring a claim in the state of Florida. And we've cited a case in our briefs.
No, Deutsche Bank is bringing the claim.
But the trial court has the inherent authority to ask these questions.
Well, Deutsche Bank held the note. They had you have a blank endorsement, and they have actual possession of the note.
What better evidence is there of standing than here is the note, the original note endorsed in blank to me?
I think that there are two separate issues, first of all. The issue of the endorsement in blank and the issue of standing, and the issue of the trial court simply asking, just show me who you are. Just tell me who you are and that you have the authority to bring this claim. And what I wanted to point out...
Let's address the standing issue,
okay,
and then we'll get to why does it make any difference who GSMP is. But tell me why it isn't enough demonstration of standing if I hand you, here is the original note endorsed in blank to me. It's a negotiable instrument. It's in my hands. What better standing can I have?
It's certainly our position that they completely waived the issue of the endorsement in blank below. They never relied upon or argued this endorsement in blank to the trial court.
They filed the note, and it's right there. I mean, it's not like the court can just say, well, I'm not going to look at it. It's right there.
They filed it, but then they never raised it or argued it. And we have no idea at this juncture why. Their argument below, yes, they pointed out we filed the original note, and that shows that we have it, but their argument was based upon the assignment.
Do you accept, for the sake of discussion, that if you read the case law, read the UCC, look at Harvey, that Deutsche Bank, in fact, did have standing?
The first thing that I have to point out in the Harvey case is that the original note endorsed in blank was attached to the original complaint.
Well,
so I
don't think that makes any difference under Harvey, but do you concede that if you've got an endorsement in blank and they have the physical possession of the note under the UCC, they're the owners of the note, they have standing?
I would agree that the endorsement in blank can confer standing. However, they never argued or raised to the trial court that this was their position, that standing was conferred upon them because they had an endorsement in blank. Their argument was that they had an assignment. Now, their argument on appeal is completely different. Their argument on appeal is, we filed this endorsement in blank and the assignment is legally irrelevant. That is absolutely not the argument that was raised to the trial court. And by failing to raise or argue this to the trial court, they waived it. The case law is very clear on this.
Well, let me go back to the trial court, because that's what I do the rest of the year. And I handle thousands of foreclosure cases. And I'm looking at the second amended mortgage foreclosure complaint, and I handle a lot of motions to dismiss. And it's, of course, a lot of attorneys, particularly foreclosure defense attorneys, sometimes confuse motions to dismiss with motions for summary judgment. And so I'm looking at the line 4 of the complaint. It says, plaintiff is now the holder of the mortgage note, and the mortgage and or is entitled to enforce the mortgage note and mortgage. And then goes on 6, the mortgage note and mortgage is in default. And then 8 and 9 starts to talk about conditions precedent and how much money is owed. Because again, motion to dismiss is the 4 corners of the pleadings. Where in there did they not properly plead standing?
Well, the first thing I would point out is that from that allegation, it's not clear whether they're the holder of the note or not.
But they said they were.
The allegation is...
You're going behind the pleadings.
No. The allegation is the plaintiff is now the holder of the mortgage note and mortgage and or is entitled to enforce the mortgage note and mortgage. So first of all, I would submit...
Not allowed to plead in disjunctive?
Well, I think
if either one of those is true, again, we have to accept that that's true for the purposes of a motion to dismiss. If either of those is true, or both are true, that confers standing, doesn't it?
If they are a non-holder with the rights of a holder, they do have standing.
Or if they're a holder. And they said, we're either this or we're that. And if I understood your answer, you agree that both would have standing.
I still think that you need to... I still think there's a problem with that allegation. I still think you have to plead whether you're the holder or you're not the holder and you have the rights of a holder. I don't think you can be both. You're either the holder or you're not.
But you're allowed to plead in the alternative. Right?
Correct.
Okay.
Correct. But I still think that the fundamental problem is that this was never raised to the trial court about the endorsement in blank. But even if the court disagrees on that issue.
But it doesn't need to be with the endorsement in blank. It's the 4 corners of the motion. I mean, it's the 4 corners of the complaint.
Well, it's also the exhibits attached to the complaint, Your Honor. This is a mortgage foreclosure action. Yeah. And if the exhibits attached don't demonstrate that you are, in fact, the holder of the note, then, of course, the exhibits control. Now, I understand, of course, there's the endorsement in blank, but, again, I have to submit to Your Honor that that issue was waived below.
Was the endorsement in blank, because I don't have the, I think I do, the amended complaint. Was the endorsement in blank, that note, attached as an exhibit to that second amended complaint?
It was attached as an exhibit to the second amended complaint. It was filed after the amended complaint was filed. And interestingly, the amended complaint, which was filed 1 month before the note endorsed in blank was filed, purported to attach a copy of the original note, which is not endorsed in blank. So we simply don't know when this occurred,
Well, but
and it
those are
was never
things that you
raised.
can handle in discovery, summary judgment, that sort of thing. So I guess what I'm trying to understand is they allege in the second amended complaint, we're a holder or we're authorized by the holder to bring this action.
Right.
And they attach the note with a blank endorsement as an exhibit.
Right.
What else do they need to do?
Well, they need to argue and raise the issue before the trial court. We simply had absolutely no idea that this was their position, that they were relying upon an endorsement in blank. All along, they relied upon the assignment, which is from
Well,
MERS.
I will not disagree that this was not a well-lawyered case by Deutsche Bank, and I'll let these guys off the hook. They weren't trial counsel. I'll say that right up front. It was a very poorly lawyered case. But that doesn't change what's in the complaint and what's attached as an exhibit. I mean, it's there for the judge to see, and he's obligated to look at the four corners of the document. Let's talk about the sanction order a little bit and the allegation that the representative that shows up didn't have the authority to settle. I'm sympathetic to the argument that whoever shows up has to have the authority to actually take care of business, take a haircut on the deal, write the loan down, whatever. But what evidence in the record is there that the person who showed up either did have that authority or did not have that authority?
Well, the first thing I would point Your Honor to is there are letters in the record that are pre-foreclosure where the defendant's trial counsel attempted to work with ASC, the loan servicer, to try to negotiate a settlement of this case and avoid foreclosure. And in those letters, they indicate they can't do anything. They have to talk to the investor. So ASC has acknowledged in those letters, we don't have the authority, we've got to talk to somebody else.
At that time, that may be true, but what we have to focus on is at the time of the mediation. So by the time we get to mediation, all I'm trying to understand is there any evidence in the record that would allow us to determine that ASC did or did not have the authority? We don't know what may have transpired in the intervening 2 years. Maybe nothing. Maybe they got all sorts of authority because of the very problems that we're talking about here. I don't know. I'm just trying to understand in the record, is there anything that would suggest, any evidence from which the trial judge could reach the conclusion that they sent somebody that could sit upright and had a pulse but didn't have the authority to do anything else?
I believe that it was incumbent upon the plaintiff. When we came...
You're the one that was saying that they violated the mediation order.
Absolutely.
It seems like the burden is on you to demonstrate, at least in the first instance, that they sent a cardboard cutout that couldn't do anything.
Correct. And
I'm trying to understand what evidence in the record is there that you made some sort of a prima facie showing that the person that they sent didn't have the authority to do anything.
well, I think first of all, it's because they didn't send a person who was the lawful holder of the note, which the order required. That was the first basis for...
You're not buying my principal agent argument, but let's get beyond that.
Okay.
I'm trying to understand what's in the record. I'm the trial judge. You come in and you say, Judge, they sent a skiff that couldn't do anything. And I'm saying, okay, prove it. What'd you do?
What we put before the trial court is that, first of all, like I said before, they sent someone who was not from the lawful holder of the note, and that they previously indicated to us that ASC has no power. They have to go to the investor.
And that was in the form of argument of counsel or evidence?
It was in the form of argument of counsel.
And was there any evidence that would suggest that in the intervening couple of years that the authority of ASC had either expanded or remained the same? They may have, in fact, not had the authority to do anything 2 years earlier, But did the trial judge have any way of knowing what authority they had? Because I'm concerned with what authority did that person have on the day he or she showed up at mediation. I don't really care what authority they had 2 years before.
Okay. There is no evidence in the record. The plaintiff's counsel proffered no evidence. There was no evidentiary hearing requested, and there's simply...
But you're the one that's taken the affirmative action. So it seems to me that in the first instance, the burden is on you to demonstrate that they violated the order. You have to prove that as opposed to them proving that they didn't.
Right, and I think we did establish that they violated the order simply by sending someone who was not from the lawful holder of the note.
Well,
and just so that I can explain the background of that, the reason why, and I think you can...
Hold on.
I'm sorry.
Well, you understand that there's not going to be a Mr. or Mrs. Deutsche Bank National Trust Company walking into a mediation, that they're going to have to send somebody. And who is Mr. Lippi to say that the person they send doesn't have ultimate settlement authority?
Well, I think that they were... Deutsche Bank, according to plaintiff's trial counsel at the hearing, is the holder of the note. So certainly they could have sent a representative from Deutsche Bank. They didn't do that.
So it's the title. So basically it's because he didn't have Deutsche Bank on his business card.
Because they did not send a representative who was the lawful holder of the note. And just so that I can explain the background of why the trial court thought that this was important, it was because from day one, they simply would not acknowledge who it was that had the note, whether it was Deutsche Bank or GSAMP, or tell the court what GSAMP is.
Well, it's kind of a...
And this greatly concerned the trial
Even
judge.
if I were to accept that that this is procedurally correct in the manner that it was accomplished, I'm still troubled by the harshness of the sanction. Is the sanction when you don't send someone with authority to mediation dismissal of the case, or can you perhaps take an interim step and tax attorney's fees and costs for the mediation and enter an order that requires them to attend a second mediation, having paid those costs and fees, and send someone with authority? It just seems that was an awfully harsh sanction. Do you think that's a reasonable sanction, assuming for the sake of discussion that the order was violated? Does that seem like a rational sanction to you?
If we were talking about just one order in isolation, Your Honor, I think you would be correct, but we're not. What the trial court's order details is that orders were repeatedly violated, and the court points out that with the first when
I know, that all goes
complaint,
back to the standing issue.
Well, no, Your Honor, they actually don't. One of the orders that the court pointed out is the fact that the plaintiff filed a motion for summary judgment, which was stricken. After it was stricken, they attempted to set that motion for summary judgment for hearing. So they tried to set a previously stricken motion for hearing. So that was a violation of a court order right there. They also violated a court order requiring them to file an amended complaint by a date certain. When you look at a pattern...
How late were they?
I'm sorry?
How late were they?
They were 17 days late.
Okay. Even, let's assume all of that were true. Does that seem like a rational sanction?
I believe that it is, Your Honor, because when you look at the pattern, what was going on here is that the plaintiff was basically trying to hide the ball about who or what GSAMP is. Now, what I think is really interesting is that plaintiff's counsel said today that GSAMP is a trust and that it's a securitized mortgage pool. You will not find that anywhere in the record.
Does it really make a difference, though? I mean, I'm trying to understand why it makes a difference if they're acting as trustee for GSMP or the Russian mafia. I mean, what difference does it make if the loan itself was a lawful loan?
I think that it makes a difference because there might be a jurisdictional argument that we could raise to show that the plaintiff is not authorized to bring this claim. If we don't even know what GSAMP is...
What sort of jurisdictional argument?
Well, for example, we don't know if it's a corporation. We don't know if it's a trust. We don't know if it's a securitized mortgage pool.
I mean, I read that in your brief, and I went back and I took a look. For example, there's a specific statute that says if they're a foreign corporation, they can't transact business unless they're registered in Florida, except that maintaining and defending and settling lawsuits isn't transacting businesses. It isn't transacting business. There's another statute that's identical for LLCs, another statute that's identical for partnerships. Again, if all they're doing, there's some investor somewhere out there in some form that may be registered in New York or Utah or Russia. Apparently, every statute that I read says that maintaining or defending a lawsuit, which they're not doing, Deutsche Bank is, but even if you take it to that level, that's not transacting business in Florida that they need to be registered for.
What I would like to do, Your Honor, is direct you to a case that we cited in our brief, which is Batavia versus United States.
I'm sorry, which case?
It's Batavia versus United States, and it's a First District Court of Appeal case. The site is 393 SO2D 1207. And what that case demonstrates, it's also a mortgage foreclosure action. And it's a case where the trial court was concerned about the structure of the corporation that was seeking to foreclose the mortgage. The trial court, the First District acknowledged the predecessor statute that Your Honor just mentioned, that, you know, if you're a foreign corporation and the only action that you're doing in the state is foreclosing a mortgage, you're not conducting business. However, that court specifically said that doesn't mean the trial court can't inquire into the nature of your business and make sure that that's the only business that you're conducting in Florida, is foreclosing mortgages.
I inquire into things all the time, but that doesn't mean it's legally dispositive. So sure, the court can inquire all it wants to, but what difference does it make?
The difference is that the court specifically asked them, tell me what GSAMP is, tell me that you have the authority to conduct business in Florida, to file this action. And they repeatedly refused to do this. Thank you, Your Honor. Now, I just in conclusion, I want to point out that the trial court made findings of willfulness, applied the Cozell factors, and the actions that were taken by the trial court were reasonable. And we would ask that the order be affirmed.
Thank you.
Thank you very much.
Please, the court. Your Honor, during argument to address the issue regarding mediation, a couple of points to make. In reviewing the motion that was filed, the motion to strike pleadings is where the issue of mediation was raised. There was not an issue raised to say that the person who appeared lacked authority to settle. That was not the argument that counsel made. Rather, the argument counsel made was that the representative who appeared was from America's Servicing Company and, in their opinion, not a representative of the entity that was the lawful holder of the note. So there's nothing in the record to suggest that the representative lacked the authority to settle. And in fact, defense counsel wrote and corresponded with ASC from the outset in an attempt to negotiate this loan.
Of course, you made that argument, and then they rebutted that by saying that that's true, but ASC said we can't do anything.
I disagree with that statement, and Your Honors will have a chance to read those letters when you review the record. What the letter said was there was an offer for a deed in lieu, and what the response was, we can't accept a deed in lieu under the investor's guidelines because there was too many liens on the property. Not that our hands are tied and we can't do anything. In fact, they sent the paperwork to be completed by the borrower with financial information in order to review whether or not there were alternatives available. So I disagree with that statement.
Then I suppose you disagree with their statement that you all waived the argument that there was a blank endorsement. So can you cite us to where in the record Deutsche Bank made that argument?
Yes, and I will start by elaborating on what is a waiver. And the Florida Supreme Court has indicated...
my question was not for you to expound upon the concept of waiver. My question to you is where in the record can you cite us to where that argument was made?
I don't know that the specific words, there was a blank endorsement, were specifically argued to the trial court. But what the trial court did have was the second amended first of all, the notice of filing the original mortgage, or note, with the blank endorsement. The court had the second amended complaint.
We know what was attached to the complaint.
Correct.
The question was
Which,
whether the argument was made to the trial court, or I guess under your theory that the trial judge has to figure that out from the attachments to the second amended complaint.
this is collective. It was alleged in the second amended complaint that the plaintiff was a holder. Holder means, under the UCC, a person in possession of the note. That is the meaning that's attributed to it under 673.3011, and that specific argument was made to the trial court during the hearing, and that's reflected in the transcript. So, yes, that argument was presented. It was presented in the pleadings. It was presented in the evidence. It was argued to the trial court that the plaintiff had holding as evidenced by the original note filed and a copy attached with the blank endorsement in combination with the argument that they are a holder under 673.3011.
Okay.
And I would point out that under the case law regarding waiver, it's simply that it be presented in the pleadings or the evidence. The issue is considered to be broadly defined, and it need only be presented. And here I think that the record goes beyond just being presented. Collectively, there was not a waiver. That issue was raised. I would also point out that the argument about Batavia and being this issue of registration and who GSAMP is quite frankly irrelevant. Batavia doesn't say that you have to be registered in order to bring a cause of action or a claim to foreclose a mortgage. And of course, the cases that we cited also indicate that you do not have to be registered with Florida to foreclose a mortgage. And in Batavia, the issue there was that the trial judge was concerned with the unusual organization that the plaintiff was in that case and merely inquired. But Batavia did not hold that they lacked standing to foreclose because of a lack of registration, and indicated that you can't force an entity to register simply to bring a mortgage foreclosure action, and those are, bringing a mortgage foreclosure action is exempt from registration. There was an issue about we need to know who GSAMP is because we might want to raise a jurisdictional issue. Well, that issue could be raised if there was a question about it in a motion to dismiss. I did not see that raised. It could also be raised if there is an answer. And in this case, the plaintiff never even got past the pleading stage, regardless of the fact that they filed the second amended complaint, properly alleged, tracked the Florida form for mortgage foreclosure, alleged that they were a holder, attached the note. I think that at this point, the issues that are being raised are issues for trial. At a minimum, should be asserted in an answer, perhaps litigated on a motion for summary judgment. Believe plaintiff has sufficiently pled the right to proceed, and if for some reason there is something still lacking in the complaint, which Florida law doesn't suggest is lacking, then if on remand the panel feels that you should allege X, then at a minimum send it back and say allege X and proceed to trial. But I don't believe that that's even appropriate here. I believe that the second amended complaint was properly pled. This should be remanded to the trial court with instructions to reinstate the second amended complaint so that these parties can have a resolution on the merits of this case. Notably, throughout the several years this case has been litigated, the borrower has never once in this record said, I don't owe the money. I'm not in default.
Thank you, counsel. We appreciate your argument.
Thank you, Your Honors.
All right, we'll take a morning recess and invite the attorneys and law student interns to join us for coffee in the attorney's lounge. We'll be in recess.